What do you think was justice served or just performed? Share your thoughts below, and don't forget to like, subscribe, and join us for the next breakdown.
Right out the gate, we've got Logan Armstrong facing a third-degree felony for evading arrest with a vehicle. That's serious, 2 to 10 years serious. But here's the twist. She's hoping for deferred adjudication. Basically, probation with a chance to wipe the conviction off her record if she behaves. High stakes, folks.
The court is calling 2022 CR 8297. And if I could have everyone in the box be silent while we're on the record, please. State of Texas versus Logan Armstrong.
Closing arguments approach, and the atmosphere thickens. Every eye is locked on the attorneys, waiting for the final strikes. This isn't just storytelling. It's the last chance to anchor truth in jurors' minds. Victory depends on emotion meeting evidence. Which side has built the stronger narrative to sway 12 minds?
Armstrong, could I have parties announced for the record for the state?
Brittany first.
Defense?
Michael Latimer.
And are you Miss Armstrong? Miss Armstrong, I'm showing you what's entitled Court's Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense of evading arrest, detention with a vehicle? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea bargain agreement, punishment is to be assessed at 4 years in the prison. The state opposes your application, and they're taking in consideration 2022 CR 8298. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
The judge intervenes now, and this moment matters. Judicial tone carries authority. Calm words can stabilize chaos. Sharp words can destroy momentum. Everyone in the room recalibrates when the gavel strikes or a stern warning lands. Ask yourself, whose side does the judge's tone subtly lean toward in this battle?
State, is that the plea?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Judge. State Exhibit 1 and all attachments.
We reviewed no objection.
Ms. Armstrong, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for...
Listen to the witness's tone: sharp, defensive, almost breaking. In court, delivery is as important as content. A shaky voice can outweigh strong evidence. Here, the testimony's fragility could either evoke sympathy or trigger suspicion. The drama isn't just in facts, it's in the fragile human emotions beneath the surface.
For you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments and review the same. All right, after reviewing states Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We will come back on.
Pay attention to the jury now. Their body language is shifting. Some lean forward, others fold arms defensively. Jurors aren't silent observers. They're human lie detectors, unconsciously reacting. Lawyers know this and tailor their performance accordingly. The question remains, are they being convinced, or are seeds of doubt spreading quietly?
On December 19th at 9 a.m. For sentencing. At that time, I'll make a decision on whether or not I would grant your application.
Notice how the judge holds off on the final guilty verdict. That's the beauty and the risk of deferred adjudication. It's like pressing pause on punishment. But come December 19th, everything Armstrong does until then is under the microscope.
That decision will be based upon any evidence I received from your counsel or from the state, and also any information from the PSI report.
I do want to state for the record, Your Honor, there was a third charge against Ms. Armstrong, the night mag number 611183, and I've been informed by the state that that case was rejected, so we didn't need to address it first.
Okay. All right, and Ms. Armstrong, you were late for court today. Why?
I'm sorry, I was on time.
No, that's why you're sitting on the front row, because you were late.
Yeah, so you weren't here at 9 o'clock. Were you here at 9 o'clock?
No, she was not here at 9, because I called the docket at 9. So you need to make sure that you're on time. The court doesn't tolerate people being.
Here, tension spikes. The prosecutor presses harder, voice firm, tone unwavering. You can almost feel the pressure suffocating the witness stand. This is where cases are won not in speeches, but in these raw, uncomfortable moments where truth trembles against denial. Would you hold steady under this relentless courtroom pressure?
Being late for court, sometimes I give people a little leeway. If it's raining, if the weather is bad, even though I'm here at 9 and people should make allowances for traffic, but do not be late for your appointments with probation. You understand? All right. All right, probation will speak with you. Oh, I'm sorry, counsel, do you want a TAP evaluation?
Oh, yes, please.
All right, that's going to be a TAP evaluation as well. I'm sorry, this goes to that. All right, the court is calling 2022 CR 8297, State of Texas versus Logan Armstrong. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Mike Latimer for the defense.
And are you Miss Armstrong? All right, you're going to have to make sure you speak up.
This cross-examination is surgical. Every question is a blade, designed to cut away falsehoods and expose truth. Notice how the lawyer doesn't overtalk. Silence between questions forces the witness to fill the space, often revealing more than intended. It's not only about what's asked, but what's cleverly left unsaid.
All right, you entered a plea on November 16th of no contest to evading arrest, detention with a vehicle. According to the plea bargaining agreement, punishments be assessed at 4 years. The state is opposed to your application. They're taking in consideration 2022 CR 8298. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes.
All right, any objections to the PSI report, state?
No, Your Honor.
Defense? I'm going to need you all to be quiet in the box while we're on the record. Deputy, is there any way to move them to the other end, perhaps? All right, state, do you have any witnesses?
No, Your Honor.
Defense, any witnesses?
Only the defendant.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, defense?
Yes, thank you, Your Honor. State, Ms. Armstrong, you understand.
Now, here comes an objection, sharp, immediate, and commanding attention. Objections are not interruptions, they're weapons. They disrupt rhythm, redirect focus, and plant doubt in the minds of jurors. The judge's response matters as much as the objection itself. Will it strengthen the argument, or reveal desperation hiding beneath confidence?
And that the judge has to make a very difficult decision today, whether or not to grant your applications for probation and or deferred adjudication or sentence you according to the state's recommendation. What did you want to tell the judge?
I just wanted to tell the judge that I am trying to get my life together. I'm trying to better myself and my career. I'm trying to do every avenue that's in.
Here's where Armstrong tries to win over the court. She talks about turning her life around, her kids, her job, classic mitigation strategy. Paint yourself as someone worth a second chance. But judges have heard it all before. So the question is, will he buy it?
Available to help me get back on track and be a better person. That I don't have to go out and commit crimes like that.
And Ms. Armstrong,
Look closely, this witness hesitates. In a courtroom, hesitation is louder than words. Jurors catch it, attorneys exploit it, and judges notice. A pause like this can fracture credibility instantly. Do you think this hesitation signals dishonesty, or simply fear of the immense pressure bearing down in this tense moment?
Strong, two individuals submitted letters of support for you. Could you identify who those people are?
Tanisha Daly is my caseworker at Austin Area Urban League and Kia. I'm sorry, you have to speak up. I can hear you. Tanisha Daly is my caseworker at Austin Area Urban League and Kia Redmond is my.
And the last time we were in court, you represented that you were anticipating getting a job. Did you secure a job?
All right, is there a reason why everybody is whispering? I cannot hear.
I can't either.
So everyone in the box, I'm gonna need you to bring it down a notch. And everyone who's in front of me, speak up so I can hear. I'm thinking everybody wants me to be able to hear so I can make a.
Right here, the defense makes a move that changes the tone instantly. Notice how carefully the attorney frames the question. It's not just strategy. It's psychological warfare. The jury isn't only listening to words, they're sensing confidence. Ask yourself, is this persuasion or manipulation unfolding before our very eyes?
Really?
Could you describe to the court what job you have secured?
I work as a monitoring a homeless shelter in Austin.
And how many days a week do you work?
It's part-time, so only on the weekends right now.
Is it full day weekends? You're anticipating working full-time eventually with this
Yes.
organization?
Yes.
Now, you understand your criminal history is rather extensive, correct?
Yes.
And what can you explain to the judge in regards to what happened in your life that would cause you so many arrests, although there's only 6 convictions? But what happened in your life that would cause you to lead that sort of lifestyle?
I was just running the street. Being loud.
Now, pass the witness.
Okay. Ms. Armstrong, who else was in the car with you on the day of this offense?
Tamara Satellite.
Was there anyone else?
Tamara Akins and Tamara's son.
This trial isn't just about justice, it's about power, truth, and the moment when silence becomes impossible. Watch closely. Every word, every glance, every objection carries weight. The courtroom transforms into a battlefield, and you're about to witness drama unfold. Are you ready to break it down?
And so, during this offense, whenever the police stopped him, he was unrestrained in the backseat, correct?
Right.
How old was he?
He was 1.
Okay, so I also wanted to go just briefly into your criminal history, just very briefly. So we were placed on deferred adjudication back in 2020 for engaging in organized crime. Is that correct?
Yeah.
Okay. And that was actually revoked in 2022. Is that all correct?
Yeah.
Pass it, please.
I have nothing further, Your Honor.
I have a question. You want to explain to me why you're going into Burlington's coat factory, stealing coats, and then running from the police with a 1-year-old in the car? Somebody explain to me, what were your thought process? And no offense against Burlington Coat Factory, I've been in there, never been able to find anything, but I don't understand what you thought you were doing, going into Burlington Coat Factory and taking items that don't belong to you.
At the time, I was just trying